All right. Hello, everyone. This is Curt and welcome to another edition of Fire Law Roundup for September 5th
Labor
of
Day
2022. Yeah, we're into September already. So been a wild week for me. Did a cross-country trip and hold on a second. So I'm still trying to get my sea legs under me. But Brad, go ahead. We gotta, I think compared to the last couple of weeks, a little on the slow side, but
which
maybe
is
that's
good.
a
We could
thing.
use it. It's Labor Day. Let's, we'll get to it and through it. And no, I think that's great that we have a nice slow day, but it's discrimination day for the most part. Like as our users should now know, every single week, as your database reflects, right? It's always discrimination suits that lead the number of reasons. What percentage do you have that? What percentage?
About 60%. About 60% of our suits are HR related. And then, well, let me put it that way. About 60% of our suits are firefighters suing the fire department over an HR related thing. If you add in unions, you're up to about 70%. You add in some of the collective bargaining issues. So basically about 70% of lawsuits in the fire service are firefighters suing their bosses. Or some variation on that theme. It's not Mrs. Smith.
And if nothing else, what our viewers should be getting is you want to lower your risk of, being sued by 60%. Stop doing things that get you sued, like discriminating or doing things that appear to be discriminating. And that's really going to be today's theme. Let's call it discrimination or not. So that's what we'll play. So first, as a really easy one in Missouri, and I've got a point of this that I want to make out of this, but a Missouri fire district settled a reverse discrimination suit. And look, this was filed 12 years ago. They ended up paying out $250,000. There was actually a verdict that got reversed just as I guess like a mistrial or something. But in any event, they ultimately settled. But it's not exciting, right? For purposes to say, oh my God, but it's 12 years. So that's what I want to point out to people before you go down the road, either way of defending or prosecuting a lawsuit, you better make sure you're ready to be in it for the long haul. And, I was meeting with some friends yesterday and they're talking about lawsuits and they have one going on for years. And, I just finished a ton of them that go on for years and the toll it takes on people is significant. And you'll be out of your position as fire chief or whatever long before some of these things settle. So really my lesson from the Missouri settlement is this goes on forever. And are you sure you want to get into that? Whether it's prosecuting, suing out, or whether it's defending, is it worth the next decade of your life? And then the question, what happens is, what do you do in the interim? Are you fixing the allegations, whether right or wrong, or are you too afraid to say, oh my God, we don't want to look like we did something wrong, so we're just going to leave it status quo? So I throw this out to everybody to, before you say, oh, we're going to sue, or no, let's defend it. Maybe there's another way. Sorry to put all the lawyers out of business, but maybe there's another way. Okay, but let's
get into the details of it though, because I think it's kind of an interesting case. This involves the Northeast Ambulance Fire Protection, Northeast Ambulance and Fire Protection District. And for those of you in the Missouri area, I don't think we have to point out that they've been involved. They went through a number of challenges roughly 10 years ago, and a bunch of lawsuits. I've got 15 or so involving there, or not all lawsuits. Some of them are disciplinary actions, but they had a First Amendment case that went up to the Eighth Circuit. Pretty interesting social media email case in First Amendment and releasing information to the media. So it looks like this case, the one we're talking about by Harold Connor, sort of predates that a little bit, but there's quite a bit of turmoil. And that's not uncommon that you see a fire department go along and then all of a sudden you get blitzed by a bunch of disciplinary actions, civil suits, and then I guess the state had to come in and intervene over some of the issues that were going on in the department. So, this isn't your typical fire department. All of a sudden, boop, we got one lawsuit, and then this was sort of part of a pretty big problem. And Mr. Connor prevailed at trial, and then there was a JNOV, and not even a JNOV, just a new trial ordered. And, the resolution was a $250,000 settlement. So we're going to talk about some other discrimination cases in a bit, but I do want to point out when it comes to race discrimination, that's the second most likely type of discrimination that we see. Sexual harassment, gender discrimination is number one. Race discrimination is number two, and there's a ratio in here, and it's changed a little bit each time I do it, but it's roughly 2 to 1, two minorities
over gender discrimination.
No. Two minorities to one reverse discrimination. This is a reverse discrimination suit. So now it's been as high as 2.5 or so, but generally it's in the range of 2, maybe a little bit over 2 minorities to every one reverse discrimination case. So, it's bottom line is it's not a one-way street. And I think a lot of people tend to think of it as a one-way street, but it's not. I mean, discrimination on the basis of race is a violation of Title VII and maybe violations of other things as well. So interesting to, keep in mind.
And look, I've always commended you. And I when I teach at the Fire Academy or wherever, I say, if you really want to know where do we start on reducing our liability, your database is it. I mean, the percentages tell you where you need to spend your efforts. And it's not on negligent driving and negligent. I mean, we've seen some of that, right? But it's not on the operational activities that is really causing you the grief. It's your own internal theoretical mismanagement, harassment, discrimination. And the third one we get to today is going to be extremely interesting. But as we spend the rest of the time talking about discrimination, the way, well, we'll get into it, but the way you react matters. So, I think people need to be looking at where can we cut our risk, right? This is a kind of risk management, and you want to know where to cut the risk. Simple, right? Well,
I know as a young firefighter, a young company officer, even shortly after I got, started practicing law, got through law school, what would keep me up at night would be Mrs. Smith type lawsuits where we didn't get to Mrs. Smith's house fast enough, or we didn't do a good job, or we got in an accident. And not that those aren't important. It's just that that's not the most likely way we're going to be sued today. And that includes company
immunity
officers.
Protections, right? I mean, the things we do in the field, there's immunity protections. There's no immunity for harassment and discrimination. So,
or FMLA or FLSA. So
yeah. And by the way, if you're watching this and even signed up for the Family Medical Leave Act seminar on Wednesday, now's the time. Third offering, great reviews. I love doing it. And your
it's
employees
important.
know this stuff. So
it's
better.
Important.
It
yeah.
is.
But
okay,
all right.
Let's go to Chicago.
Yeah.
Not for pizza necessarily, but let's go there. So Chicago is a really complicated suit. I'm trying to make it interesting or easy. It is interesting, but easy. So it's complicated, but I think I have a higher, view of this to make it a little bit easier. Obviously, the details of the testing, which we'll talk about, are on your site. But so 12 African-American fire lieutenants with Chicago Fire Department have sued. They claim they're discriminated against in a captain's exam based on their race. And they claim that the method of scoring is what discriminated is the basis for discrimination. Now, interestingly, there's repeated references, as we'll get into this, to the violation of certain sections of, I believe, the CBA, right? The agreement. And they say that so I'm not quite sure why that's discrimination alone, because you violated contract. Breach of contract is a breach of contract claim, much simpler than, frankly, discrimination claim, right? Words on paper are easier than discriminatory intent to prove.
Yeah. I can explain that one. I can.
Oh, good, please.
Yeah. Because if the resolution or the solution to a breach of contract in a collective bargaining environment is a grievance, and the union owns the grievance.
Okay. So you think the union didn't want to pursue it?
Well, I don't know if they did or didn't, But if you're an individual who's being discriminated against, you don't want to have to go to the union, and then you have to have the union's attorney handle it, and they get to settle it and all that. Whereas when you allege race discrimination yourself, Title VII violation. Now, whether or not that'll be a defense for the city and say, now, wait a minute, we have a collective bargaining agreement, this should have went to arbitration. So.
Okay,
because it does, it does affect other people. That's why you have collective bargaining, because if they prevail, other people are not going to get promotions, and that's one of the reasons why you have a collective bargaining agreement, is so that those things can be worked out collectively, and not this person wants it done this way, this person wants it done a different way. So
right. So I think it's first, if you're going to be one of those people, right, you've got to determine, am I going left or right, right, union or private? So here, and look, the scoring is complicated, but basically what they said is that the scoring process had an adverse impact on African Americans compared to Caucasians or non-African Americans. And they brought it to the city's attention, and they allege in the complaint that the city, again, this is just the lawsuit, there's no decision, this is early on, right, where you catch these things right at the beginning, but they allege that the city could have corrected this by taking one of a number of actions, but they didn't. And basically what you have is you have weighting of written, oral, and seniority scores. Now, I thought when I started this, we were going to see seniority being the place that there was discrimination, right? Because usually you could say, well, wait a minute, seniority, well, you gave seniority and there's more Caucasians who are higher up the chain, so they got more points or something. But, or, the more Caucasians have been employed longer, but who knows? But that's not what it is. And Chicago, correct me if I'm wrong, is not under a mandate to equalize their the population of African Americans in the department.
It's
right?
Funny, you and I, we cover so many cases, Brad, that it's hard. And believe it or not, you and I covered this. I'm just looking at it. June 27th, 2022. We covered this.
Okay.
And they dissolved the consent decree.
There you go.
Okay.
So
there you go. So.
But that really wasn't the main issue here. So here they allege that, which is interesting, that the method of scoring did not comply with the CBA. So that, if it's proven, does assist in saying, why did they breach the CBA, right? And so that might make out a prima facie or on its face case of discriminatory intent, because they had what they were supposed to do and they didn't do it. And now the burden may shift to say, why did you violate these sections if you did it all? So effectively, they're going to start with did you breach the contract? Right? Or were you allowed to? If you just follow the contract, there's no discrimination, right? The union adopted it. So here, basically what they're saying is that on this 2017 promotional exam, there was a curve applied to various aspects of this exam, and the curve didn't favor the African Americans. And they gave different weight based on oral and, and different categories. And the way this is what I found was weird. So they gave more weight to a more correct answer. Now that to me seems crazy. It's a correct or more correct is, and I'm not an expert on testing, right? And very complicated.
In, education, research, and methods, right?
Yeah, but this seems crazy. It's if the answer is correct, the most correct answer, it's you're right, but you're more right. That doesn't make sense. But they gave like 30 times the number of points, 30 points for the most correct and 1 point for the least correct. And I'm gonna raise a question to you. And then they unevenly weighted it, right? So, okay, you gave the better answer, but here's my question. How is that race discrimination? Everybody was free to give the most correct answer. How does the weighting affect on that? And that's the main part of their suit. I really thought they were going to go with seniority, but that's the main part of their suit.
Yeah, it has to do with the 80% rule. And that's at the end of the day, we don't even look at whether or not a particular question could have had an impact. We don't even look at that. What they look at, whoever is looking at it, they look at, does the actual hiring burden the minority group in a way they're not at least 80% of what the majority group scored. So if African Americans score, if Caucasians score, let's just say 100, and the average score for African Americans is 75, that it is presumptively and rebuttably, but it's presumptively discriminatory because it's not 80% of what the majority group gets. So I think at the end of the day, they're saying that the test was flawed. Okay. But I think the more interesting issue now is what's the resolution, and what they proposed was by changing what you were talking about, by changing those scoring matrices, then you would get to a point where you eliminate that discrepancy. And that's what they're suggesting. And they pointed it out to the city, and the city said, yeah, but we're not going to do that. Or at least according to the complaint.
Yeah, and who knows what the request really was, what their answer really was, but it's all going to come out in the wash. So we'll figure it out.
It is.
The brutal part to all of these types of cases, as you know, they go on for years. People are holding the position of lieutenant who may be removed. Then there's back pay. If there's a victory, you get back pay. The people who are lieutenants lose their time or not. I mean, there's all that. And that's, God, there was a suit so long ago where maybe you'll know it off the top of your head. It must have been like 5 years ago, but where the lieutenants or whoever were removed, right? And then came the captain promotional test, and the lieutenants wanted their time counted. And everybody else says there's a further exacerbation of discriminatory intent because they shouldn't have been in that position. And now we only get a year as lieutenant. You're crediting them with 12 years to a position they never should have had. And I thought that case, I don't remember it so long ago.
There's not one case. There's a bunch of them.
Many cases like, okay.
Right. And what happens also is the plaintiffs will go into court and they'll ask the court for an injunction to block promotions because they don't want to see that happen. Because if you don't make lieutenant when you're supposed to, then you're not going to be eligible for captain. And if you don't make captain when you're supposed to, you're not going to make battalion and right on up the line. So what they say, this is what they go into court and say, we want a temporary restraining order, we want a preliminary injunction right now, blocking any further promotions, which sounds reasonable.
Except the city comes back and says, wait a minute, that's a safety issue. We need people in the front seat who are qualified.
Departments, I think it was Cincinnati, but there's been a number of departments across the country that have gone 6, 8, 10 years with no promotions. Okay. And again, to a judge who doesn't really understand the fire service and has what appears to be meritorious claims on the one side, and they'll say, oh yeah, okay, so we're going to block promotions temporarily. And then the case, as you point out before, the case drags on 6 years, 8 years, 10 years, goes to appeal, comes back down, and there's no promotions. And now you do have that, even a year, you can have that safety problem. Okay. So I don't know if you can avoid these. I look at a lawsuit like a Mayday. Okay. We can become very good at handling a Mayday, but at the end of the day, we're so much better off avoiding the Mayday if we can possibly figure out how to avoid it. And it's the same thing here with the lawsuits. And I don't mean roll over on every claim, but at some point we've got to figure out a way to avoid the lawsuit.
Right. Agreed. Okay. Let's go simple case, not discriminatory. Just as a note, this is always the bad one. West Virginia firefighter here was just sentenced finally to 14 years for a firehouse sexual assault. He was also a police officer, and he was both paid and volunteer in the fire service, as it seems. He tried to have consensual sex with a female. She said no. Now she's 16 years old. So I don't know what the law in West Virginia is on consensual sex, but nonetheless, she clearly said no. And he decided to, I guess, rape her or have non-consensual sex. And then he was sentenced.
Yeah, I got to bounce this off you because I blogged about it. I kind of thought about it. And I'm saying, well, this is unusual. All right. This is a very unusual case. This is brought by the U.S. Department of Justice.
Yeah, the FBI was the main investigator in this.
Sexual assault is a state crime.
Yeah.
Okay. So, and looking through the documentation, he wasn't charged with sexual assault. Now, I don't know if in addition to the federal crime, he was charged state-wise. Yeah, I see that. You see that expression you got on your face? That is the expression I had, right?
I wonder if he used the internet to seduce her. I wonder if you use the internet to seduce her. That would bring in the FBI.
It could,
Maybe?
but I think that his criminal offense is violating her civil rights. So and I'm wondering if maybe I'm just speculating, and I guess we probably shouldn't speculate here, but
Yeah.
I'm wondering if maybe the age of consent is 16 or 15 in West Virginia, and so they really didn't have a criminal offense in terms of sexual assault. So they said, all right, no problem, we're going to handle this as a abusive of a position and a civil rights violation.
I don't know. I really have to read the charge, and
yeah. But I thought it was like as soon as I started getting into it, I'm saying, like, why is this a federal case? Why would the U.S. attorney get involved in a sexual assault case, which is typically a state law type of charge?
Yeah, and the only thing I was thinking of is whether there was some internet predatory. If she was 14, I could see it. 16, so I'm not sure. But I don't know the answer to that. In any event, what's always bad about this is, a plumber rapes somebody and it's not headlines. A firefighter and a cop does it. It's just bad for the fire service. It's like when our people steal, you steal from the Little League, it hits the paper for a day. A firefighter steals from his fire department. Oh my God, it's the worst thing in the world. And look, it's bad. This is all bad, but just the firefighter is just so bad for the fire service. And for any of the, we're supposed to be trusted people. And I unfortunately, the world, look, there's bad people in everything. There's no industry, the church, right? I mean, pick one. There's bad people in everything. But to characterize or to generalize that, well, that bad person is, representative of everybody in the service is just horrible. And I think people do that. People with a chip on their shoulder want to do that. And they use things like this. It's horrible, and not much more you can say about that. Sure. Okay, so I think the most interesting part, and this is extremely interesting case. If you are, watching TV and watching us, turn off the damn TV right now, because this is so interesting. At least, to me, I thought this was great. We're going to Connecticut, and here we have it's a suit, right? It's just a filing of the suit, but wow, is this interesting. So a Connecticut battalion chief has filed a gender discrimination suit. I'm going to see if I can do this not from my notes and summarize this first, because what we have is we have an assistant chief who's female, and she wants to be promoted to a higher chief level. Did I get that right? Or battalion?
No,
she wants to be assistant. She
wants to be an assistant chief, right?
And she is a battalion chief. And she's been there for a while. This male comes in, right? And I'm going to read this because a male candidate who got the position, right? He worked as a civilian dispatcher. He became a firefighter in 2005, which, by the way, the year the female chief was promoted to battalion chief, right? So she is so much more in terms of years qualified than he was, but it gets better. He held that position until he was promoted to battalion chief in 2020, but served only in 11 months, right? She's been a battalion chief for a very long time. However, and I'm not degrading the individual, I'm not degrading the male, but when you compare the two, so before his promotion to battalion chief, right, the male candidate had no supervisory experience at the fire department. In the span of less than 12 months, he is, as you say, skyrocketing from supervising no one to supervising 11 people as battalion chief to supervising more than 50 as the assistant chief, the position the plaintiff, the female battalion chief wanted. So the female candidate is so much better qualified on paper. I'm not saying personality or anything else, but so much better qualified than the male candidate. So here is what is unbelievably interesting. I'm not going to say unbelievable. The chief, well, first of all, the replacement, the guy who's leaving says, this female, assistant or a battalion chief should really get this job. You should be my replacement. I mean, even the person who holds the position believes that that the battalion chief, the female battalion chief, is very well qualified for this position. And clearly on paper, she is. Again, we don't know personalities. We only see what's on paper. However, the chief now takes action, which I am promising is not going to look good. he drafts a new job description for the assistant chief role and makes, as the complaint, the lawsuit says, a game-changing distinction, right? But it's true. He removes all the relevance of the supervisory experience, which the female battalion chief has, levels the playing field down to where 11 months is now acceptable, making the male candidate an acceptable candidate, right? And just levels the playing field, which is somebody's going to question, why are you removing all of the experience requirements to now get this other person deemed qualified on paper? And nonetheless, or even worse, now the male candidate, right, passes the female candidate. They ask different questions, for the first time. I hate this, but nonetheless, there's an oral examination for the first time ever, which I think is the allegation would be, well, oral questions, now we can score those differently. And, it's not as clear as how long have you been in the position, how long have you had supervisor experience. In any event, the basis for this oral questioning, which are horrible generally, right, on paper is the way to go. If you want to avoid a discrimination suit, don't have oral questioning. And he gives it equal weight. So just in short, they take out a history of requirements, remove them, allowing just enough so this person with 11 months in the position versus the female who's got years in this position are now equal, and they then implement oral testing. I am telling you, this looks bad. If this is true, wow. And that is not the best way to avoid a suit. There is right or wrong.
It's a good way to get sued. It's an excellent blueprint to get sued.
Oh, I think it is. I think if you want to write a book, how to get sued in 3 easy steps, then certainly make it so a non-qualified male individual on paper,
lesser qualified,
right? Now will allow him to, get rid of your qualifications so that men and women are equal. But here's the question I have for you. If you were going to defend him, this is what I would want to say. But wait a minute, and maybe you'd end up with a reverse discrimination suit, maybe not. If the sexes were reversed, if they lowered it so that a female could become qualified, right? Let's assume it was reversed. The male's got 15 years, who easily could have had the position. The female only had a year, and they reduce it so that everyone's on playing field. Would that be reverse discrimination, or would that be opening it up?
Oh, that's okay.
That would be okay, right?
Well, there's people that would say it's okay,
And the males would say reverse discrimination. You discriminated against me for being male because you want to bring women up.
Right.
So goose and gander here. And maybe that's what they're thinking. Look, I would never give this advice. I'd be like, listen, you want to fix it? Do it after you made the promotion while there are no candidates, then lower it so it's not personal to anybody, right? And then you do it. They knew this chief was retiring. I'm sure this wasn't a surprise that this, very well qualified assistant chief was retiring. I imagine they could have done this a year before. The problem is you didn't do it a year before. Why? Because this person, the male who had 11 months of experience, wasn't there. I would love this lawsuit. Not that I want to sue fire departments, so don't get me wrong.
I had this lawsuit. I had almost exactly this lawsuit.
And which side were you on?
I was on her side.
Yeah, that's the side you want to be on.
Absolutely.
Don't
and she ended up getting the promotion. They actually had to create a new assistant chief's position. She got the promotion and back pay, and the city looked awful. I mean, it just looked awful. So now, again, there could be things that we're not aware of in this particular case, but I know in the one I was involved in, it was not. The fire department came out. The chief's reputation was very badly damaged. And why?
Right. And look, there is a way to do this legally if you have a true belief that this individual is not qualified. So you don't change the qualifications. You go through letting this individual be the only candidate and right, not doing anything discriminatory. And then you say, listen, this person is not qualified for this position. What do we say about promotions? People reach their highest level of incompetence, right? Now, I'm not saying that with regard to this individual.
Right.
No comment with regard to this chief. But
Right.
maybe they could have said, listen, we think you're great at the job, or you're okay at your job, but you've reached your, you've reached your capacity. Now that's tough because you got the person who holds the position allegedly saying she'd be great, but at least you run through it. You disqualify the person, right? And saying you're just not acceptable. We're going to go and now we're going to change the requirements, but you don't do it before, right? You don't do it before, you do it after, if you have a valid basis for rejecting that individual. This is such a great case. And maybe it wasn't obvious to the city when they did it. It should have been, but man, looking at this, at least through the plaintiff's lens, right? Remember, we don't know the truth. We know the allegations, but these are pretty bold allegations. If these allegations are true, the city's going to lose this case. Let's be fair. And if they're not true, fine. But this is not true or not. Don't do this. Right? There's a better way if you truly have an unqualified candidate.
Yeah, I think that the cases I'm familiar with, and there's several that kind of overlay with this one. Some race, some personality, but often there's a sense that the person who is the senior person has a difficult personality that won't be a good fit for the position. That's the sense. Now, there's also bias that interferes with your assessment of whether or not they're going to be a good fit. That's a whole nother. We're not going to get into all the things that go into bias, but certainly I think that if you feel that someone's not going to be a good fit, before you pull something like this, you really want to get an objective view about whether or not it's your own bias that's causing you to see this person as not a good fit, and not just say, well, everybody that we talk to thinks this person is not a good fit. That still is not especially when the person is in a protected class, that is not good optics for that kind of decision. And this is what it'll look like in federal court.
Yeah. And again, if true, my star witness is the person who just retired saying, did you really say that you think she'd be a great fit? If the answer is yes, bye-bye, you lose. But look, there's always another side.
Yeah, absolutely.
We're just viewing this through the lens of the complaint. We don't know what the true story is. And, with that, unless we got anything else, I'm going to say enjoy the Labor Day. And listen, thank you from Curt and I. Thank you to everybody who's working today. The public's home having fun. Curt and I are here to serve you guys, but and men and women. But if you're working today, it's just another day in emergency services.
Be safe, and if you're not, enjoy the holiday. So.
Yeah, either way, thank you to everybody.
All right, man. Thanks, Brad. Okay, take care, everyone.